Hear ye. The Court of Appeals for the 14th District of Texas is now in session pursuant to adjournment. God save the Constitution and this honorable court.
Thank you. Good afternoon. I'm Tracy Christopher with the 14th Court of Appeals, and the other two judges on our panel today are Justice Ken Wise and Justice Jerry Zimmerer. This is the first Zoom oral argument for the 14th Court of Appeals. We hope that it goes well and that we find this process to be useful for the parties in the case. We are going to hear today cause number 14-19-00239, a criminal case. And we're going to have speaking today, Brian Weiss, representing the appellant, Matthew Christopher Fish, and Trey Picard, representing the state of Texas. And we have given both sides 15 minutes for oral argument. Mr. Weiss, we have a timer that shows that you've asked for 5 minutes for rebuttal. Is that correct?
It is, Your Honor.
All right. Then Zoom is a little difficult in terms of interrupting for questions like we normally do. So if you see us waving, stop. We are ready when you are.
May it please this honorable court, it's my privilege to represent the appellant, Matt Fish. In a fictional Alabama courtroom 85 years ago, one of my literary heroes, Atticus Finch, reminded the jury that the one place where any man ought to get a square deal is in a courtroom. In a real-life Brazoria County courtroom 14 months ago, that didn't happen when Matt Fish stood trial for murder. And there are two primary reasons why. Number one, trial counsel failed to request a critical jury instruction on concurrent causation, one that would have not only immeasurably fortified his defense of accident, for which no instruction is required, but would have given jurors a vehicle to give effect to that theory. And secondly, the trial court abused its discretion in admitting an extraneous offense appellant committed 2 months before the primary offense under the unsupported and unsupportable rubric that the defense opened the door to its admission, when in truth and in fact, the state kicked the door in during its redirect of Brittany Smith. This court's decision in Signs, a decision authored by Justice Brown, where two of our three panel members today participated, makes two things clear. Number one, trying this case without a jury instruction on concurrent causation is not only doing Hamlet without Hamlet, but it's ineffective assistance of counsel. Justice Yates, 19 years ago this month in Marquez, concluded that where trial counsel acknowledges that his failure to request a jury instruction is not tactical, and the trial court would have erred in denying that instruction, that's objectively deficient conduct. And I submit—
Mr. Wise, with respect to that, do we have in the record an actual statement from Brittany with respect to concurrent causation that we can evaluate, or should we just evaluate her testimony and the video?
Your Honor, I think the court is free to do both because, as one of our assignments of error makes clear, trial counsel was deficient in failing to elicit that statement that Your Honor just alluded to. But even without it, I submit that the whole of the evidence that is more than a scintilla is certainly sufficient to have warranted the instruction. And I think that three cases essentially distill this issue and both guide and simplify this court's task. Gonzalez, authored by Justice Christopher, joined by Justice Wise, restates the well-settled notion that any evidence from any source, more than a scintilla, even if contradicted or impeached, and with all reasonable inferences to be drawn therefrom, viewed in the light most favorable to the charge, is sufficient. Sandoval, authored by Justice Wise, makes it clear that more than a scintilla is a deliberately low standard. And most recently, in Ranzier on rehearing, authored by Justice Spain and joined by Justice Zimmer, the court made it clear that, quote, concurrent causation is an issue for the jury. And I think that when we look at that body of precedent through the prism of Signs, which is really a sequel to this case, this record is every bit as strong to fortify the notion that trial counsel's request should have been granted. Had it not been, it would have been error. And I think the state's response, quite simply, is rounding up the usual suspects as they did in Signs. Certainly the same cases and the same argument that the evidence was not sufficient to warrant the instruction in Signs, again, doesn't achieve any
sorry, have you seen a concurrent causation case that doesn't involve driving while intoxicated or driving under the influence?
No, Your Honor, because the research that I've engaged in reveals at least the two where the claims were sustained. I believe one is Nugent from the Corpus Court of Appeals. The other is Sines from this court. And I think that the state's position, re-urging those same claims that were raised and rejected in Sines, is a bridge too far in convincing this court that it wouldn't have been error to deny a requested instruction on concurrent causation. And again, I think it's important that 6.04 defines conduct, not just as an act or omission, but a culpable mental state. And again, whether it's testimony that the appellant could have been driving as slowly as 8 miles per hour, that he did not intend, as he told Detective White, to either hit or hurt the complainant, and certainly Brittany Smith's race gesti excited utterance on the 911 call that the complainant, quote, jumped out in front of the appellant's vehicle. And while that testimony may well be impeached, certainly by Brittany herself, as Justice Wise makes clear in Sandoval, impeached, contradicted, regardless, is certainly more than a scintilla. And I think that once we get past deficient conduct, Your Honors, I think prejudice necessarily stems from it, because I think this court needs to keep three things in mind. Number one, as Justice Christopher made clear on remand in Frangias, one mistake is enough to warrant a finding of prejudice. Number two, the Supreme Court said that my burden is less than a preponderance of the evidence. That is the proverbial 50% in a feather. And then thirdly, prejudice is not the same test as a sufficiency standard. And certainly when we look at the four-part template that this court is permitted to look at in determining prejudice when a jury instruction isn't requested, the first, the charge as a whole. And with all due respect, this is a charge with more holes than the Iraqi Navy. It is a charge that did not, because it could not, fulfill the mandate that each judge on this panel is embraced, that a charge has to do more than prevent confusion. It's got to affirmatively lead the jury to the disposition of fact questions. Number two, the state of the evidence in contested issues, I think, speaks for itself. Third, arguments of counsel. And while all factors are allegedly equal, I think, like Orwell said, some are more equal than others. This is it. Number one, because the Supreme Court and the CCA have made it clear that jury argument isn't a substitution for an affirmative submission. But more importantly, Justice Wise and Jenkins made it clear that an incomplete instruction hamstrings lawyers, primarily because lawyers can argue whatever they want to. And you know what? It can go in one ear and out the other, and probably usually does. But with an affirmative submission, the jurors may not agree with the law, but it's the Sermon on the Mount. It's gospel, and they are not free to reject that out of hand. And finally, any other evidence the record reveals as a whole. I wish I had a jury note like in Gilbo. Oh, by the way, where's the self-defense instruction, Judge? I've got the next best thing. I've got the leader in the clubhouse. I've got a docket entry at page 345 of the record that says that even without an instruction on concurrent causation, this jury took almost 11 hours to acquit the defendant of a knowing and intentional murder and found that his act wasn't clearly dangerous to human life. I submit, Your Honors, that with that critical instruction, that it's reasonable to believe that this jury would have at least convicted the appellant of negligent homicide, an offense that comes as close to accident as one can get in Texas without an instruction. And briefly, in the 3 minutes that I have left, excuse me, the state maintains that this wasn't prejudicial because of the submission of lessers. Justice Zimmer's opinion in Bibbs disposes of that. In the 2 minutes and 46 seconds I have left, I just want to touch on the admission of an extraneous offense, the dirty linen that is all but obscured by the minute peg of relevance that it's hung upon. Frank Sinatra said it best in high society. There are rules about such things. Indeed, there are, and they were violated with impunity in this case. 404B and 403, there is no analysis either by the state or certainly by the trial court at the time this inherently prejudicial and presumptively inadmissible offense was admitted.
But even if the trial court was wrong about opening the door, we could still uphold the admission of the evidence under 404, couldn't we?
Absolutely, Judge, because obviously what you're referring to, the judge protection rule, the appellate prosecutor's prom date, is not without exception. First of all, if the door wasn't open, then that's the end of the story. Secondly, even if it was, and assuming that it came in for relationship of the parties. The Court of Criminal Appeals has made it clear in Smith that it's still subject to a 404B and 403 analysis. And as we pointed out in our extensive briefing, 3 of those 4 factors favored the appellant. Moreover, in Varelis, which was authored by Judge Holland on rehearing, ironically and tellingly, the state cites Judge Kiesler's dissenting opinion of Varelis. Varelis makes it clear that regardless of what limited purpose it was offered for, the instruction should have been given both contemporaneously and in the jury charge. And as the court knows from our other assignments of error, that didn't happen and that damage wasn't mitigated. And I submit, as we pointed out in our original briefing, this evidence was inadmissible under any of the theories that the court charged the jury. And simply by way of harm, I would point out that the state argued it in rebuttal to denigrate the appellant's defensive theory. And as, again, Justice Zimmer pointed out in Bibbs, when the defense is powerless to respond to that kind of argument, that's the hallmark of harm. And as the Court of Criminal...
Yes, I was looking at the trial counsel's affidavit, and I was a little confused on what instruction he should have asked for at the time the evidence came in versus what was actually in the jury charge.
Yes, Your Honor. Varelis makes it clear in footnote 4 that even if it came in under relationship of the parties, that should have been the limiting instruction that was given both at the time and in the charge, and that didn't happen. Our position is if it only came in to rebut the false impression that Brittany Smith allegedly created, and make no mistake, this record reflects that whatever door was kicked in happened during the state's redirect. The jury's discretion wasn't channeled. It certainly tainted the integrity of the proceedings. I submit that the collective effect of both of these 2 assignments, as well as those which I haven't argued today, compel the conclusion that this was a trial with an unreliable result because it was fundamentally unfair. We ask this court to reverse appellant's conviction.
All right, we'll now hear from Mr. Picard for the state.
Good afternoon, everyone. May it please the court, can everyone hear me?
Yes.
Okay. I'm gonna limit my comments to just the extraneous issue and the concurrent cause issue. I think that's probably all we'll have time for. As far as the rest of the brief, obviously I'll answer whatever questions the panel may have. However, I think this is probably gonna be it. I'll begin with the extraneous material that came into evidence. And I want to be sure that there's a firm understanding of what the evidence was that the jury actually heard. In his reply brief, the attorney for the appellant points out that, quote, trial counsel admitted an extraneous offense that appellant pointed a loaded handgun at the complainant over his objection that evidence of relationship with the parties, but the record tells a different story. And it's true. When Brittany, the fiance of the appellant, testified, the state asked her, did the defendant point the gun at Tina or Christine? No. She goes on to testify. On this incident, December 11th, did he ever point the gun at you? No. Did he ever threaten to shoot his mom? No. I point that out because I think it's a significant difference in terms of what the jury actually heard. And I can understand there being some confusion about that because in the state's notice of extraneous offenses, it says a defendant pointed the gun at the complainant or the victim. But there's a significant difference, I think, between actually pointing it and pointing the gun at the deceased, telling her to get out versus pointing it up in the air and not specifically threatening her.
Well, then what was it relevant for at all?
A relationship with the parties. Now, I know there's been some discussion by appellate counsel, Mr. Weiss, that it was offered as a, because trial counsel, defense counsel opened the door. I cited a number of cases in my brief that talk about when such evidence is admissible. The first being when it rebuts a claim of self-defense. The First Court of Appeals in Price talked about a scenario where a prior protective order became admissible because the defendant specifically raised the issue of intent, just like here. It also rebuts a claim that the deadly conduct was that the conduct was an accident. Specifically, there are two defenses here. First, that the fact that he ran into his mother with his truck was an accident, and that he had no intention to do this. Obviously, the problem with that theory is that he told Detective White shortly after being arrested that he did in fact intend to bump his mom with his truck. With that, kind of hard to say it was an accident when you admit to acting intentionally, and therefore the self-defense became a necessary defense at trial. But to rebut the appellant's claim that this was an accident, and to rebut his self-defense claim, I think there's a significant body of case law that supports that. As far as
So are you arguing that the fact that he didn't point the gun at his mother lessens the prejudice?
I think it does. I think it lessens the prejudice, and it goes to whether or not this affected a substantial right in terms of limiting instruction. We're discussing an issue that counsel is saying that caused him a unfair trial, and that it casts doubt about the fairness of the proceeding. Says the evidence of this exchange, which occurred in a family altercation in December of 2016, about 60 days prior to the instant offense, says it's not relevant, violates 404B, unduly prejudicial. Lawyer was ineffective for failing to ask for limiting instruction, and he suffered harm. Certainly, as when evaluating whether or not the appellant was harmed by this information, by what the jury actually heard, the Court of Appeals is free to look at everything from opening statements to what was said at trial to closing argument. And in preparing for this argument today, I went through defense counsel's closing statement, which I think offers a pretty good analysis as to why all the information that occurred back in December is both relevant, that it had strong probative value in terms of everything that happened during that exchange, and that really a limiting instruction would have made no difference.
So you're saying relevant under 3836, not under 404?
Both, actually. I think the Price case and both the Garcia case that's cited in our brief shows that it can be admissible under both standards. It's Article 38.36 obviously is subject to the rules and requirements of 404B and the limitations of 4043. In Garcia, the Court of Criminal Appeals recognizes that again. And so I understand you may have a statute that says it's relevant background evidence that both the state and the defense counsel can use. However, it still has to pass muster under 404B and 4043. And in this case, it does. The defense counsel specifically refers to not only all the facts and circumstances that led up to this, including a pattern of stalking and harassment by Christina, the bad acts or the texting and other bad blood that existed between that family in the year leading up to her death. And in one part in particular, I want to quote this to make sure it's accurate, but he tells it, this is defense counsel, tells the jury, folks, she's been there in the house before. She got warned out of there with a gun. It doesn't get much more serious than that. And when Matt, pulls up at that second, she's at the threshold of the garage looking into the house, and he sees what he believes to be an occupied habitation. If he did intend to bump her, the law excuses that. He specifically calls the jury's attention to this extraneous offense, or this matter of him brandishing a firearm. And he tells the jury that they should rely on that for their determination on whether or not he's guilty or not guilty. It's not a limited purpose. And so I think any limiting instruction mid-trial would have been pointless. Also worth noting, defense counsel says this prior to the state bringing it up in its own closing argument. It's only after the state gets a chance to respond that the prosecutor talks about, well, if he had just pulled the trigger, this may have happened back in December instead of February. I called it an awkward reference to it, but it's a response to something that clearly trial counsel recognized was important, that he relied upon to get the jury to say not guilty or believe his self-defense claim. And so what we're seeing on appeal is completely different, or a completely different theory than what the appellant relied upon in order to hope to get either a lesser included offense or not guilty. I don't think you can say now that this suddenly deprived him of the right of a fair trial or somehow cast doubt on the validity of the proceedings. As far as so we have a relationship with the parties that the defense counsel specifically asked the jury to consider. It was a common theme throughout the trial. In order to justify self-defense, which he had to use because his client spoke, trial counsel needed some evidence to show that his client had reason to be afraid of his mother. Problem is that evidence didn't exist anywhere except one time back in December of 2016. And so he wanted to talk about the events leading up to this, including the fact that Brittany and the appellant had been assaulted at that time. The trial court initially said you can talk about the fact that an arrest warrant had been issued because of that incident, but you didn't want the parties to get into the detail. It wasn't until defense counsel on cross-examination of the appellant's fiancee, Brittany, said, had you ever been assaulted by the deceased before, Christina? And she said yes, back in December. At that point, the trial court felt, well, the events of that evening are in now and they've been brought into issue. And it's after that the state was allowed to bring up evidence related to not only the assaults that occurred at that time by the deceased upon appellant and his fiance, but also his holding of a gun and telling her to leave. In that context, I think it's hard to say that the state kicked the door open when it was something that the defense counsel did with a very friendly witness who testified and I think possibly put the best possible spin that she could on that particular exchange. And as far as why counsel chose to bolster his self-defense claim with the prior extraneous offense or something that's so outrageous and inflammatory in order to justify his use of self-defense, the record's silent. The ineffective assisted counsel claim only goes to the limitation instruction, which I respectfully submit that it would have done no good because it occurred after a limiting instruction was provided in the jury charge, and I'm not sure what good a limiting instruction does when you specifically call the jury's attention to it and tell them that they can rely upon it specifically in determining whether or not his conduct was justified. In the time I have left, I'd like to...
The time to ask for the limiting instruction is when it comes in. So I don't really think that his closing arguments later changes that. I mean, he objected to the evidence coming in. The judge let it in anyway. And at that point, he was supposed to ask for the limiting instruction.
And there is an argument to be that if something negative comes in that you wanted to keep out, you can try to talk about it in a certain way to lessen its impact. But here, he uses as a justification. So even if, yes, if he had asked for a limiting instruction at the time that this evidence was offered, trial court would probably have given it to him. He says in his affidavit that the failure to ask for limiting instruction was an oversight, and that's probably true. But the closing argument, I think, shows that by the time all the evidence was in and his case had rested, he had launched into the whole extraneous event as justification. And so I don't think you can argue both. I don't think you can argue, even if he was entitled to a limiting instruction at the time, in terms of whether or not he was deprived of a substantial right in this case, when in fact you relied on it to justify your conduct, I don't think that's supported in the law. Certainly it doesn't go to harm. So even if the court finds, and I talked about Varela in my case, in my brief, counsel's pointed out the Varela's case as well. In that situation, you're dealing with a case where there was no direct evidence of the defendant being involved. And basically, he was tried in Varelis only on the extraneous conduct that was admitted over his objection. Now, the failure to do a limiting instruction, and specifically even a limiting instruction in the jury charge, was error. And so the Varelis case makes sense. That there are some strong dissents in that case that I pointed out. But the reality is, here we have a situation where there's no dispute as to how the offense occurred. It's the question of intent. It's whether or not it was the defendant's state of mind at the time that he committed this offense. Further on, I think defense counsel concedes that these are all, he says, quote, "These are all very issues in this case, and it goes toward Matt's state of mind, and it comes down to that." And he uses the conduct of the parties and the relationship of the parties leading up to this event to justify that. So I understand that there's the point about the state not, arguing a different point at the time that the evidence was admitted. But again, it's an open question as to whether or not it was supported on any other theory of law. Here, there's a Article 38.36 reason as to why it was admissible, and other justifications that if it falls out of the unfair prejudice and the extraneous conduct limitations of 404B. So with that, we're talking about a completely different argument that the jury heard at the time this evidence was offered. To say that it somehow deprived you of a fair trial at this point, I don't think is supportable based on this record or in the law. With the time I have left, I'll just briefly mention the Sines case, since the implication is this is part 2. In a nutshell, you have intoxication manslaughter versus an intentional homicide. In terms of a harm standard, Sines was decided on a some harm standard in terms of whether or not there was a jury charge problem. In this case, they left out an application paragraph. Here, we have an egregious harm standard, which counsel points out in his pre-submission brief. And I think that's significant, that the level of harm you have to show for this particular alleged jury charge error doesn't rise to the same level of egregious harm standard, unlike the Sines case where it was based on some harm. Now, thank you for your time.
Thank you. We'll get Mr. Weiss back on. All right, we ready?
May it please the court, very briefly in terms of concurrent causation, when it comes to harm, the whole is greater than the sum of its parts. That's number one. But number two, counsel has suffused the two harm standards, one of some harm versus egregious harm, without any basis. And this is why. Because while Sines turned on whether there was some harm because the error was properly preserved, in this case, that only goes to deficient conduct in terms of whether or not it would have been error to have refused the requested instruction on concurrent causation. I think that it's clear that this failure on trial counsel's part not only deprived appellant of a valuable defensive theory, which is, again, concurrent causation, but also essentially put his thumb on the scale by taking this critical jury instruction out of the purview of the jury itself. Secondly, in terms of the 404B issue, Justice Christopher, I believe you made a great point. The fact that the extraneous offense might not have been as prejudicial as the allegation in the state's pretrial notice only drives a stake through the heart of its probative value, if any, and relevance. Number two, and again, Justice Christopher, the fact that you pointed out that the time to have sought an instruction was at the time the evidence was admitted and in the jury instruction. And that goes back to, again, what Justice Wise pointed out in Sandoval, that
it's 2 o'clock.
That jury instructions aren't ever an adequate substitute for a jury argument is never a sufficient substitute for an affirmative submission. And I think it's critical that the Court of Criminal Appeals and Mitchell pointed out that these kinds of limiting instructions are vital to the administration of justice. And rather than mitigate the harm, rather than have that jury charge, which each of the panel members today has reaffirmed, then what we have here is a jury charge that falls far flat of its ultimate mandate. And in terms of 44.2b, I would only point out the fact that in Lopez, the Court of Criminal Appeals has said if this court is unsure as to whether or not the error was harmful, it has to conclude that it ultimately wasn't. In Burnett, I believe, authored by Judge Cochran, she makes clear that if this court has grave doubt about the impact of the error, that the tie goes to the runner. And that's
So,
just,
let me ask you a question. If trial counsel embraces the extraneous offense in closing argument, doesn't that cut against his argument that it only should have been admitted for a limiting offense, a limiting purpose?
no, Judge, because I believe that he can literally have his cake and eat it too. He can embrace it. In other words, it's the notion that when an extraneous offense comes in erroneously, there's a body of case law that dates back to the early 70s from the Court of Criminal Appeals. It says that you make your objection and then you have to utilize that to explain, rebut, or meet the harm that's attendant upon the admission of that extraneous offense. So no, I don't think that one necessarily means you can't have the other. And that's why these limiting instructions were so critical. Because if we assume, as we must, that the jury followed the court's instructions, even if you binge watch Law and Order, you're still not going to be able to understand these limiting instructions that are anything but limiting. And that's where I think the ultimate harm is. And appellate jurists as varied as the late Antonin Scalia and David Newell have held that in close cases, I submit this isn't a close case, but if it was, that in a close case, it's what we learned in Little League, the tie goes to the runner. I would only conclude by pointing out that the criminal justice system, as Judge Cochran pointed out in Robbins, makes two solemn promises to any defendant accused of any offense: a fair trial and a reliable result. In this case, fulfilling the first was improbable. Attempting to fulfill the latter was impossible. And the byproduct of that fundamentally flawed trial, Your Honors, is a sentence in the state system of 17 years, in the federal system of 204 months. But in the real world, it's a sentence of 6,205 days, tainted by the fundamental unfairness of this trial. We ask this court to sustain these claims and reverse this conviction and remand the matter for a new trial.
All right, thank you, Mr. Wise, Mr. Picard, for your arguments. The case is submitted and we are adjourned.
Thank you.